Has the government of Guam been afforded due process? The answer varies depending on who you ask. Governor's legal counsel Sandra Miller believes it hasn't. In the latest filings in the Ordot consent decree case, the parties continue their dispute over who the Attorney General's office truly represents. The AG's office contends it does in fact represent the government and have provided meaningful representation. But Miller wrote, quote, "The Ninth Circuit is likely to reach the inescapable conclusion that the government has been and continues to be denied a meaningful opportunity to be heard by this court's orders preventing a full substitution of counsel and allowing the AG's office to continue to participate on behalf of the receiver. The government's success on its appeal is highly likely," end quote. As we reported, the governor's office is seeking an emergency stay until an appeal in the case is resolved by the Ninth Circuit. Miller argues there is a clear conflict of interest as she contends the AG's office filings indicate that their office, by its own admission, had not been representing the government since April 2011, and that its client is the Guam Solid Waste Authority, which by the court's direction is under the direct control of the federal receiver. The governor's legal counsel has been trying to get the government in unconflicted counsel to act in GovGuam's best interests moving forward. She said the AGO's abandonment of the government violates all of its fiduciary duties to the government. As a matter of professional responsibility, an attorney owes a duty of loyalty to his client. But the AG's office opposes any stay. Assistant AG Kathy Focus argues in her opposition that the AG's office does and always has represented the government of Guam in both this case and the condemnation case. She adds the court resolved that there are no conflicts of interest, writing, quote, "The hostile assertions made against the AG's office by the office of the governor in its pleadings are shocking. The AGO represents the government of Guam, including its line agencies and autonomous agencies, and not the receiver, both in this case and the condemnation case." Focus went on to write, "The governor's office has offered no credible evidence of clear error by the court or asserted there has been a change in controlling law or that substantially different changed circumstances exist that would result in manifest injustice," end quote. But Miller contends the government will be irreparably harmed unless the stay is granted or the court replaces the government with the Guam Solid Waste Authority as the sole party to the consent decree and litigation, and requires the federal receiver to operate the GSWA in such a way that it will ensure that obligations are met under Guam law and consent decree obligations are funded without further involvement or funding from the government of Guam.